In previous chapters, you learned that the ownership of real estate, or a freehold estate, represents one or more of the rights within the bundle of rights, the ability to possess, use, transfer, encumber, or exclude others from the property. You also explored how estates could be freehold or leasehold, depending on whether ownership or possession was conveyed. In this chapter, we turn our attention to the ways in which that ownership is held. Property can be owned by one person alone or by two or more parties together. Understanding these forms of ownership is essential because each determines how title is transferred, how taxes are paid, and what happens to the property when an owner dies. Ownership of real estate can be held in severalty, meaning by one person, or it can be shared among multiple parties in various co-ownership forms such as tenancy in common, joint tenancy, community property, or partnerships. Modern ownership structures also include entities such as trusts, corporations, and limited liability companies. The type of ownership chosen affects everything from how the property can be sold to how it is inherited. The simplest form of ownership is sole ownership, known legally as tenancy in severalty. The term severalty comes from the idea that the owner's interest is severed or cut off from all others. When one individual or entity, such as a corporation, government body, or nonprofit organization, holds title alone, they are said to own the property in severalty. The owner has complete control of the property and can use, sell, lease, or transfer it in any lawful way without consulting another owner. For example, if John Doe, a single man, purchases a parcel of land, he owns it in severalty. If he later decides to build an office building, sell the property, or leave it to his children in his will, he can do so without needing permission from anyone else. Government-owned land, like a city park or federal forest, is also owned in severalty because it is held by one legal entity. Upon the death of an individual owner in severalty, the property passes to their heirs through probate. In Arizona and other community property states, when a married person wishes to acquire property as their sole and separate property, the non-purchasing spouse must relinquish any marital interest by signing a disclaimer deed. This ensures that the property remains under one spouse's exclusive ownership and is not considered community property. For instance, if John Doe, a married man, buys a home and his wife signs a disclaimer deed, the title reads, John Doe, a married man, as his sole and separate property. When ownership is shared by two or more individuals or entities, it becomes co-ownership, also known as co-tenancy. Co-owners or co-tenants share the right to possess and use the entire property, though their ownership interests may differ in percentage or duration. There are several forms of co-ownership, each with its own rules about survivorship, transfer, and division. The most common form of co-ownership is tenancy in common. This type of ownership is presumed in Arizona when two or more unmarried individuals take title together unless otherwise stated. Each tenant in common owns an undivided interest in the property, meaning that no co-owner can claim a specific physical portion of it. For example, if John and Mary buy a rental property as tenants in common, they both have equal rights to use the entire property, even if John owns 60% and Mary owns 40%. Tenants in common may own unequal shares, but each holds the same right of possession. They can sell, mortgage, or will their individual interest without needing the consent of other co-owners. When a tenant in common dies, their share passes according to their will or through the state's laws of descent, rather than automatically transferring to the surviving owners. For instance, if John dies, his 60% share might pass to his daughter rather than to Mary. His daughter would then become a tenant in common with Mary. Tenancy in common is flexible, but can present challenges. Because all co-tenants must agree on major decisions, selling or improving the property can be complicated. For example, if John wants to build a garage on the shared property, but Mary objects, he cannot proceed without her approval. Similarly, a co-owner's ability to sell their interest may be limited by the property's divided nature. since buyers are often reluctant to purchase partial ownership. If co-owners cannot agree, one may petition the court for a partition or forced sale. Partition divides the property into separate parcels of equal value, allowing each owner to hold full title to their portion. If physical division is impractical, such as in a single-family home, the court may order the property sold and the proceeds divided according to each owner's percentage interest. In contrast to tenancy in common, other forms of co-ownership include joint tenancy, community property, and community property with right of survivorship. These forms are often used by married couples or family members who wish to simplify inheritance and avoid probate. Community property with right of survivorship is unique to states like Arizona. It allows a married couple to own property together with automatic survivorship rights. This means that when one spouse dies, the surviving spouse automatically inherits the entire property without the need for probate. For example, if John and Jane own their home as community property with right of survivorship and John passes away, Jane becomes the sole owner immediately. Under Arizona Revised Statutes Section 33-431, both spouses hold undivided shares of the whole property, and both halves receive a new fair market value basis for tax purposes upon the death of one spouse. Either spouse may terminate the survivorship right by recording an affidavit of termination, but this does not end the community nature of ownership. It merely removes the automatic inheritance feature. In contrast, community property without survivorship rights allows each spouse to leave their half of the property to someone else by will. For instance, a husband could leave his share to his children from a previous marriage while the wife retains her half. The court would then divide the property accordingly. Determining whether property is community or separate in Arizona depends on how and when it was acquired. Generally, property purchased during marriage is community property, while property owned before marriage or received by gift or inheritance is separate property. For example, if Jane inherited land from her parents, that land remains her separate property unless she adds her husband's name to the title or mixes it with community assets. Other factors also affect how property is divided upon divorce. Courts in Arizona aim for fair division, considering factors like the length of marriage, earning capacity, child custody, and separate assets. Although Arizona is an equal division state, equal does not always mean identical. Instead, judges strive for fairness, which may involve one spouse keeping the home while the other receives financial compensation. Another important co-ownership form in Arizona is joint tenancy with right of survivorship. In this arrangement, two or more people hold title together, and when one dies, their share passes automatically to the surviving owners. Unlike tenancy in common, no probate process is required. This form is often chosen by spouses, siblings, or business partners who want property to transfer quickly upon death. Finally, property can also be owned by a partnership or business entity. In a general partnership, title is taken in the name of the partnership, and all partners share profits, losses, and liability. This form is often used for real estate investments or development projects, where multiple parties combine resources and share risks. Review summary. Property ownership can be held individually or jointly. Sole ownership or tenancy in severalty means one person or entity holds complete title. In Arizona, a married person can hold property separately by using a disclaimer deed. Co-ownership occurs when two or more people hold title together. The most common forms include tenancy in common, joint tenancy, community property, and community property with right of survivorship. Tenancy in common allows unequal shares and separate wills, while joint tenancy and community property with survivorship automatically transfer ownership to surviving co-owners. Community property ensures equal ownership between spouses for assets acquired during marriage, while separate property refers to assets owned before marriage or received as a gift or inheritance. Understanding these distinctions is vital for real estate professionals when advising clients, preparing contracts, or ensuring clear title transfers. Discussion. Why might a married couple in Arizona choose community property with right of survivorship over joint tenancy? Answer. It allows automatic inheritance without probate while maintaining community property tax benefits. How does tenancy in common differ from joint tenancy? Answer. Tenancy in common allows ownership in unequal shares and passes interest to heirs through probate, while joint tenancy provides equal shares and automatic survivorship. Why is a disclaimer deed important for sole ownership in Arizona? Answer. It ensures that a spouse has no community property interest in property acquired individually during marriage. What happens when co-owners cannot agree on the use or sale of property? Answer. A court may order partition or a forced sale, dividing the property or proceeds according to ownership interests. Closing remarks. Ownership structure determines how property is managed, transferred, and inherited. Whether held individually in severalty or shared among multiple owners, the form of title carries legal and financial consequences. Real estate professionals must understand these distinctions to ensure that property transactions reflect clients' intentions, comply with state law, and protect ownership rights. In Arizona, this knowledge is especially critical given the state's community property system and unique survivorship provisions that simplify inheritance and preserve fairness in ownership.